So Bev isn't going to be taking the bench at Monday's hearing. Then who the heck is? Hello, 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 and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people who have opinions about all things going on in the true crime community, including what the heck is going on with the Karen Reed trial. So I find this deeply fascinating because, and I just stumbled upon this like a few minutes before I hit the record button, that if in fact Judge Bev is not going to be taking bench at Monday's hearing, then who is and why? I have to wonder, is this in direct response to the back and forth between the defense ever since the defense filed their motion to dismiss counts 1 and 3? We have not heard a single peep from Judge Bev aside from that one order she had filed in regards to sealing the identities of the jurors. But other than that, she really has been pretty quiet behind the scenes. And I have to wonder, now that the Commonwealth has also responded, and now that the defense has responded to their response, which we're going to get to in 1 second, what does this possibly mean? Now, what's even more fascinating is that it's still listed as a trial assignment conference. So, if in fact this is to go over the defense's motion to dismiss, is this just maybe the Massachusetts website didn't update yet? Is it a error on the website, or are they going to dig into this? Are they going to just simply set a date for that evidentiary hearing? I don't know, but who's going to be sitting on the bench instead? Well, the Honorable Katie Rayborn. Now, why is that name significant? Well, if you don't know, back in, I believe it was 2017, maybe 2018, Katie Rayborn was the prosecutor who convicted Michelle Carter of involuntary manslaughter for essentially coaxing her then boyfriend to unfortunately end his life. And I have to wonder. I mean, it seems like she has a pretty interesting career and background. I remember loosely following that case at the time, a really, really disturbing case, very upsetting. There's actually been a miniseries spinoff, I think, with Elle Fanning that was released on Hulu a couple of years ago as well too. That wasn't that good. But just like True Crime Gal reports, I'm also interested to see not only how she interacts with the Commonwealth, but with the defense as well too, because as we know, Bev didn't seem like too much of a big fan of Alan Jackson, Mr. California, coming in, flying in, especially with those pretrial hearing. So I'm curious to see if this judge, if she is going to be handling the motions aspect specifically, and maybe Bev is just recusing herself from this specific hearing, how things are going to go down. If things are going to go in the favor of the defense, are they going to get a fair shot to dig deeper? Because that's all we're really asking for here, is for us to just see if we can get confirmation from the jurors' mouths that yes, in fact, you did vote 12-0 not guilty for counts 1 and 3. So now I want to get into the defense's response to the Commonwealth's response. I have it pulled up here, so we're going to do a full read through. I haven't read through the entire thing word for word, but I have gotten the main gist of it, and it's pretty much their response is indirect, a direct echo of what they were saying in their earlier motion, then their affidavits as well too, but now they're just specifically addressing what Morrissey and friends had addressed in their opposition reply. So let's read through. Defendant Karen Reed's reply to the Commonwealth's opposition to her motion to dismiss. Now comes the defendant Karen Reed by and through undersigned counsel, and hereby respectfully submits this reply to the Commonwealth's opposition to her motion to dismiss. The Commonwealth's opposition is perhaps most notable for what it does not dispute that, according to information from four deliberating jurors, the jury had reached a unanimous decision, excuse me, that Miss Reed is not guilty on two of the three charges pending against her, namely counts 1 and 3, the biggest one being the murder 2 charge, which was count 1. The third count was the leaving the scene of personal injury or death. The Commonwealth's insistence that Miss Reed must nonetheless be forced to run the gauntlet once more is based on several clear fallacies. So then they quote some case law here, Green versus United States. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberation, the appropriateness of a Tui Rodriguez instruction, the defense was provided no opportunity to be heard regarding the declaration of a mistrial. So remember, too, with the defense's opposition, they had stated, well, it's their fault. They didn't speak up. They should have said something. And also too, in regards to David Gannetti, the first note from the jurors came in that we're at an impasse. Not the second or third note where they were like, "Hey, we're actually." I believe there were three notes. The third note where they're like, "We're starkly divided," etc. They're referring to the first note where the jurors were like, "Yeah, we are at an impasse." And David Gannetti said, "Okay, like we think you should read the Tui Rodriguez instruction." Bev said no, but sent them back in, I think back in for lunch, and then encouraged them to continue their deliberation. So that was what the opposition was really just harping on, is the fact that, hey, you guys didn't speak up and you were all for the mistrial back then. What changed? But as many attorneys on a lot of these different law tube channels have commented, is just like a juror, people are allowed to change their minds and opinions and change their strategy as things are going. And of course, you're not going to state that as the attorney in front of a judge, but that I can only think that that is probably what was going on in the back of their minds, is what's the best strategy for my client now? And maybe it is to keep your mouth shut. So that's just me speculating, but let's continue. Rather, upon receiving the final jury note, the court sua sponte declared a mistrial with no warning to or solicitation or objections from the parties. And that was from either party, right? She didn't check in with the Commonwealth or the defense either. Second, the jury's note did not explicitly indicate an impasse on all charges. Opposition at 1. To the contrary, it was readily susceptible to the interpretation proven correct based on information received post trial from deliberating jurors that the deadlock applied only to the multiple offenses, including within count 2 and not counts 1 and 3. And remember that fifth juror, too, according to Turtle Boy, he did report that even though he was voting guilty on the count 2 charge, he also did confirm that counts 1 and 3, that, yeah, we were all unanimous, 12-0, not guilty, which is interesting, right? Third and finally, the defense respectfully submits that neither the Commonwealth nor the court carefully considered alternatives before declaring a mistrial. The record reflects no discussion of any such alternatives, including, importantly, inquiry regarding whether the jury had reached an impasse on all, as contrasted to just some of the counts. And that's true. I mean, it wasn't clear. It wasn't clear, are they voting not guilty on everything, or guilty, or what are they starkly divided on specifically? Can we get some clarity? That conversation was never open up for discussion. The underlying idea of the constitutional protection against double jeopardy, one that is deeply ingrained in at least the Anglo American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. So, again, they're quoting Green here. Even if the first trial is not completed, a second prosecution may be grossly unfair. it increases that financial and emotional burden on the accused. I mean, we just saw too earlier today, Karen Reed posted up her house, and I believe that it's been up for a couple of weeks now, but she listed her Mansfield house on Zillow, and it's a nice freaking house if anybody's in the market to buy, just saying. But yeah, and I can only imagine how much she's spent in legal fees over the last few years, because this has been going on for years. And the more hours that they're clocking up, the more money is coming out of her pocket. So yeah, are they just trying to run out the clock? Prolongs the period in which, and that's kind of my theory too, and I don't like to get too much in speculation land, but I will say part of me feels like the Commonwealth wants to push, 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 and prolong and just do whatever they can to just continue this financial burden on her so that she can't afford an attorney like Alan Jackson anymore. It does feel like the longer this plays out, yeah, I could definitely see that as being part of a strategy, not to be too speculative, but one has to wonder, and this is a good call out. Prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. So, again, more case law, Arizona versus Washington. And then another case law, United States versus Martin Linen Supply Co. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Yeah. Thus, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution compels the same result: dismissal. Given the unambiguous post-trial evidence, it would be simply wrong to require the defendant to obtain two acquittals from two different juries for the same crime. Exactly. Yeah. If one set of jurors are saying, yeah, she's not guilty, then she's not guilty. The Commonwealth's leading argument is rooted in pure formalism, that no verdict was entered on the record in court. See opposition at 5. But precisely this formalistic mode of analysis has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. See motion at 5. Again, more case law, Ball versus United States. The reception of the verdict and discharge of the jury is but a ministerial act involving no judicial discretion. However, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. Hudson versus Louisiana. Holding that judicial grant of new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize trial judges to enter judgments of acquittal in jury trials. Indeed, the prohibition against double jeopardy was plainly intended to condemn the abhorrent practice of English judges exercising power to discharge a jury whenever it appeared that the Crown's evidence would be insufficient to convict. Washington. The Commonwealth's heavy reliance upon Bluford versus Arkansas, because remember, they had a lot of case law quoted from Bluford versus Arkansas, fails for reasons set forth in the defense's opening motion. In that case, after the foreperson reported that the jury was unanimous against conviction on certain charges, the jury was sent back to continue deliberations. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberation that it was still the case that all jurors believed the defendant was not guilty of capital or first-degree murder. Here, by contrast, 4 deliberating jurors attest that there was a final unanimous agreement that Miss Reed is not guilty of second-degree murder, persisting through the conclusion of deliberation. Here, by contrast, 4 deliberating jurors Deliberating jurors attest that there was a final unanimous agreement that Miss Reed is not guilty of second-degree murder, persisting through the conclusion of deliberations. According to one such juror, Juror D, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anybody going to know that we acquitted Karen Reed on count 1 and 3? Alan Jackson's supplemental affidavit. Most importantly, unlike Bluford, this was not a case where the defendant was charged in a single count which incorporated lesser included offenses. Indeed, the Arkansas law at issue in Bluford did not even permit the jury to return partial verdicts of acquittal, noting that the jury's options were limited to two: either convict on one of the offenses or acquit on all. Here, by contrast, the defendant was charged with 3 standalone counts, and state law expressly allowed for partial verdicts on any charges with respect to which the jury was agreed. Only if the jury, in fact, was deadlocked on all 3 should a mistrial on all 3 be declared. Any other result would require either a verdict, if a unanimous one had been reached, as the affidavits in this case reflect, or at minimum, further deliberations. Yeah, pretty plain and simple. The lack of manifest necessity to support a mistrial provides a second independent basis for dismissal. While there is no doubt that a jury deadlock may constitute manifest necessity, the Commonwealth unsurprisingly cites no support for its contention that a deadlock on some, but not all, separately indicted charges supports declaration of a mistrial with respect to all counts, contrary to the Commonwealth's characterization as unambiguous. Opposition at 7. The jury, now at issue here, was facially susceptible to 2 alternative interpretations: that the jury had reached an impasse as to all charges, or 2, that the deadlock applied to only some of the charges. So on multiple lesser included allegations within a single count, such as count 2, the information received from jurors post-trial proves the latter interpretation was correct. So again, meaning that the deadlock only applied to some of the charges, not all. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. So again, that was what I was talking about earlier, is that under the court's instruction, when Bev was like, listen to me, listen to my instructions, don't pay attention to anything else, that you should continue deliberating until you have a verdict on everything. So at that point, they might be asking themselves, okay, well, we don't have a verdict on everything, so I guess we don't fill out the form at all. And that's why the lack of communication, whether it was done intentionally or not, can be problematic and is very confusing. Given that there was no deadlock on 2 of the 3 counts, it follows that there was no manifest necessity to dismiss the jury without receiving its verdict on those 2 charges. The defense does not suggest that the court was required to give the jury new options for a verdict, Bluford again, only that it should have asked the straightforward question of which of the separate indictments the professed deadlock related to. Yeah, simple question. Don't you guys all want to know? I love these people too who are like, it's all hearsay. But if the shoe was on the other foot, you guys would be banging on doors, banging on pots and pans like it was freaking New Year's Eve, going up and down the streets with your megaphones too, and saying, hey, DA's office, what are we going to do? We got to fight for this. We got to make sure that Karen Reed gets locked up because she was convicted 12-0. They voted guilty. But because that's not the case and it's not leaning in your favor, you don't want to see justice to be served. And I mean, for me, it's like, if any one of us were in a similar situation, I mean, we look at even again the Alec Baldwin case, where regardless of whether you think he was guilty or not guilty, there will never be another opportunity to try him for that again because of the lack of transparency on the prosecution's end to disclose evidence to the defense. So, and she ruled, and the judge in that favor ruled in favor of the defense to dismiss the case because of that. And because of all of this nonsense, I mean, this is only the beginning of it. The case should have been dismissed the moment the inverted video ended up being played in front of the jury. I mean, come on now. So I I have to wonder, how is this judge going to respond on on July 22nd in Monday's hearing? In essence, the Commonwealth's contrary position asks this court to close its eyes, look away, right? Look the other way. To close its eyes to the possible, or even, as here, very likely existence of partial and unanimous verdicts on some, but not all, separately charged counts to avoid the risks of juror coercion. Yeah, because remember too, they meant, and I love that they're quoting certain phrases that the Commonwealth used in their reply as well, because it does highlight, I mean, how egregious is this? The fact that they're inciting there was jury tampering or juror coercion when they're not the ones who reached out to the jurors reached out to them. So, and if you're so nervous about what they're gonna say, then get their verbal confirmation, get them to sign another affidavit, get get them into a hearing, and get them to testify this under oath. I don't understand why it's that hard. I really don't. I don't understand why this is such a big issue for any side, because don't it comes down to this. Don't you want to know the truth? The Commonwealth utterly fails to acknowledge that Roth, Bluford, and a juvenile are clearly distinguishable because they all arose in the context of lesser included offenses contained within a single charge. The Roth court's concern about coercion makes sense in that context. When the jury reports a deadlock on one charge, follow up questioning regarding the possibility of reaching a verdict on a lesser included offense would imply that the jury should consider conviction on the lesser offense. But this logic does not extend to the present circumstances, and no existing precedent cited by the Commonwealth requires judges to disregard the possibility of partial verdicts when the verdicts would be on standalone separate charges, such as those in current indictments. Mass at 788 permits taking verdicts on less than all of the charges set forth in separate indictments, a juvenile versus Commonwealth, where a complaint or indictment in multiple counts charges multiple crimes. A general verdict could be returned as to one of the counts despite deadlock on the other counts. Mass R. Crim, P27, reporter's notes, providing that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to the single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts. See Commonwealth versus Foster. Affirming trial judges taking impartial verdicts on two of four separate indictments and observing to conclude that the jury could have felt pressure to convert provisional verdicts against the defendant in final ones, and to abandon all doubts they may have had privately entertained runs counter to the clear instructions of the judge and amounts to mere speculation without any support in the record. So yeah, it's BS. Commonwealth versus La Fontaine. Affirming partial verdicts taken after judge asked jury whether it had reached a verdict on any of the indictments. She didn't ask them. She didn't even ask them. She just said, I'm declaring a mistrial. I'm not going to make you deliberate anymore. See ya. I'll put you on the bus right away. I'm going to give you a little, like, one last chit chat, and then I'm going to go, take whatever donuts you want out of the jury room, take what you came with, and I'm going to go get some sun. That's the way it came across to me. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being able once and for all to conclude their confrontations with society through the verdict of a tribunal they may believe to be favorably disposed to their fate. Cruz versus Commonwealth. Quoting United States versus Jorn, plurality in opinion and the danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. Washington. Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some but not all standalone count. I mean, that's a great point too, because it's like, well, guys, don't you want to know if you potentially got a conviction? No, because everybody knows how this is going to go down, and the Commonwealth is so dead set on seeing Karen Read locked in prison for life. They want to get her on that murder 2 charge. That's all they care about. They don't care about the other 2 charges, I'm convinced. Because even if she does get convicted on count 2, which I highly doubt, but even if she does, that's less time in jail than if she were to get convicted with murder 2, less options. So I really feel like in a way they're trying to run out the clock as much as they can, try to burden her as much as they possibly can financially so she can't afford high-powered attorneys like Alan Jackson, Eliza Little, and even David Gannetti too. So I think this is a great point. Not only are they talking about, hey, not only is this gonna hinder us, but yeah, it's gonna hinder you too. Because don't you wanna know if somebody voted guilty? Like, isn't that good information and data for you to use in your retrial? Apparently not. Apparently you don't care. Commonwealth's attempt to shift blame to the defense overlooks the black letter rule that prosecution alone bears the heavy burden of establishing manifest necessity for a mistrial. Washington. The defense's request for a Tui Rodriguez instruction did not, of course, reflect any implicit concession that the jury was deadlocked on all counts, nor did it commit the defense to any position regarding whether the court should sua sponte declare a mistrial. A discussion with counsel, such as that occurring twice earlier in response, and this is what I brought up in one of my last videos too, is that Bev had addressed counsel any other time a note had come through from the jury. The question, if they could get that cert report, and any other time that they came forward with a note saying, hey, we're at an impasse. We can't come up with a unanimous verdict. All of those times, she opened up the discussion on, hey, what do you guys want me to do? Do you want me to continue? How make your arguments on what we should do. Should we declare a mistrial or not? And that last note came after she read the Tui Rodriguez instruction and she took it upon herself to just say, hey, I'm not going to discuss anything with you guys. I'm going to bring the jury in and then I'm going to declare it a mistrial. I'm not going to give anybody the opportunity to argue. I mean, again, and it's from both sides. The Commonwealth didn't get to make a case, and neither did the defense. So, yeah, great point. A discussion with counsel, such as occurring, yada, 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 instead was required. It is indisputable that the court provided no opportunity for defense counsel to be heard regarding the declaration of a mistrial, as opposed to the appropriateness of a Tui Rodriguez instruction. In short, mere silence, absent an opportunity to object, does not amount to consent. I mean, yeah. And there's just so many examples of that too that rings true. Just because we don't say anything doesn't mean that we give you verbal confirmation that says, yeah, we agreed to a mistrial. The cases relied upon by the Commonwealth are readily distinguishable on the basis or even support the defense position. See Commonwealth versus Betesaya, don't know how to say that, Betsea, holding that where the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial. The lack of an objection from defense counsel cannot be construed as consent to such action. Compare Commonwealth versus Curtis. The judge declared a mistrial upon the defendant's request. Pellegrin versus Commonwealth. Finding that the defendant plainly had the opportunity to object, where the mistrial was declared after a voir dire and colloquy after the jury were cleared from the courtroom. In only one case cited by the Commonwealth, Fuentes versus Commonwealth, was the defense, as in the present case, afforded no opportunity to be heard before a mistrial was declared. But there, the Commonwealth fails to mention the crucial fact that the jury's note preceding the declaration of a mistrial expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. So it was clear in the foreman's note in that specific case law that the Commonwealth had quoted or cited in their reply that they didn't have a unanimous verdict on either, so therefore they're completely deadlocked, and it was distinctly mentioned in the foreman's note to the judge. So therefore that would make sense. That would be the appropriate step. There are no options. There are no alternatives. But that's not what happened in this case. Now, I know there's a lot of speculation too about the foreman. Why did they word the note a certain way? Was the rest of the jury room able to see and read that note? I mean, I don't think the judge would read out a note if the foreman was trying to sneak in some sneaky stuff without going over it with the jurors first. I'm sure in the jury room, everybody wanted to read the note. The foreman probably wrote the note. He probably read it out loud to the class and then handed it off to the clerk. The clerk handed it to Bev, and that was the best, I guess, way that they could express why they were deadlocked. So but it wasn't specific enough. But that, again, I don't want to go into the area of there was some kind of, um, there was some kind of inappropriate behavior on the foreman's part in that regard. I don't really buy into that. I think they were probably exhausted and tired, and they're like, we don't really know how to express that we're deadlocked on these things. Maybe we can just talk to the judge afterwards. I don't know. In those circumstances, while the more prudent course would have been to consult with counsel, the record did not show the consultation would have been produced any fruitful alternatives. Here, the opposite is true. The note did not expressly state that the deadlock applied to all counts, and it is patently clear from the affidavit submitted in support of the defense motion that consultation with counsel may well have produced a fruitful alternative, namely inquiry regarding whether the jury had reached a unanimous verdict on any of the three counts, which, according to the information from jurors A, B, C, and D, would have resulted in acquittals on counts 1 and 3. In any event, Fuentes did not alter the court's clear obligations, repeatedly reaffirmed since that decision before declaring a mistrial. 1. Counsel must have been given a full opportunity to be heard, and 2. The trial judge must have given careful consideration to alternatives to a mistrial. Ray versus Commonwealth. The Commonwealth cites no support for its suggestion that an attorney who receives a call post-trial stating that the jury had acquitted his or her client must simply hang up the phone and not act upon that information. Exactly. The jury's agreement that Miss Reed is not guilty on counts 1 and 3 reflects the results of its deliberative process, motion 4, not the contents of jury deliberations or thought processes of jurors. Commonwealth versus Moore. See also Commonwealth versus Cassidy. Remarking that trial judge was rightly loath to examine the entire panel to attempt to determine the impact of the errant juror on the rest of the jury. Taking a sip. The defense is not relying upon jurors to attest to any particular statement made or incident that occurred during the jury's deliberations, the effect on anything, on any juror's vote, or any juror's mental processes concerning a verdict. Rather, the defense is relying upon the simple fact that the jury's agreement that Miss Reed is not guilty on the relevant counts, permitting juror testimony that a mistake was made in entering the verdict on the verdict form. The permissible subjects of juror contact listed by the Commonwealth are not exclusive, and the Commonwealth fails to cite any authority establishing the fact of a jury verdict constitutes a prohibited subject matter under Rule 3.5c. We're wrapping things up now. At the same time that the Commonwealth criticizes the defense for perpetually infringe or purportedly, yes, purportedly, the defense for purportedly infringing upon the jury's deliberative process, it is also paradoxically faults the defense for reliance on hearsay. That's the key thing. It's thing that we keep seeing around Twitter, right? It's hearsay. It's hearsay. Then let's get the evidence. Let's just nip this all in the bud and shut everybody up, right? That's all we want. But the affidavit by counsel in Commonwealth versus McCallop attesting to alleged juror bias was no less hearsay, and the Supreme Judicial Court squarely held that it entitled the defendant to further inquiry on the subject, and that's all they're asking. They're not asking for you to dismiss the charges. They are just simply asking for an opportunity to take that next step to present a case and see, okay, can we at least get a shot at seeing if there's something to this? And if there is, then our client has a right to a fair trial. For the second trial, she shouldn't get charged. She shouldn't get charged with the same charges and have to fight against possibly getting convicted for life in prison based on the fact that you just don't want to have an evidentiary hearing, Bev. So I almost wonder again if she just doesn't want to deal with this. And she is like, I'm just going to remove myself from this completely. And maybe, who knows, maybe the case will just get dismissed. I don't know. I feel like low key she wants the case to get dismissed and she doesn't want to have to deal with this anymore. That's just my opinion. But let me know what you guys think in the comments below. The defense submits that the same result is warranted here for all of the reasons set forth above, as well as it in its opening motion supplemental memorandum and attached affidavits. The defense respectfully requests that this honorable court issue an order dismissing counts 1 and 3, respectfully submitted for the defendant, Karen Reed, by her attorney. So this one was written by or signed off first by Martin Weinberg, the new attorney. So interesting stuff. I will link to this in the description below so you can take a read through for yourself. But what do you guys think of that? What do you think of the defense's reply to the Commonwealth's opposition? I mean, I think they did overall a really good job of poking holes, specifically with the case law that the Commonwealth was using to make their argument in the opposition. And what do you know? The defense was able to even respond in a much shorter way than the Commonwealth. So I wonder, do you think the Commonwealth is going to respond back? Are we going to wait until that trial assignment hearing on Monday with the new judge? I don't know. But before we leave today's video, we got some fun news here. We have a email that was sent from Courtney Proctor. Oh yeah, Courtney Proctor to the governor of Massachusetts. And it just goes to show, like, and Mark Bettero says this all the time. It's just so funny because it's so true how tone deaf these people are, and they're just so unaware. And Michael Proctor, I don't think these people understand. Michael Proctor is the last thing on anybody's mind. It's the last thing on Morrissey's mind. It's the last thing on the Commonwealth's mind. And it's definitely the last thing on the governor's mind. especially with like all this craziness with the the assassination attempt with Trump. Like there is a lot of stuff going on in the country right now. Like nobody cares about your poor brother, Mikey Proctor. Nobody cares. He's not the victim in this. He's not the victim, Courtney. So the best thing for you to do would probably be to take a back seat and to not do anything. But I thought this was pretty funny because, again, it just further institutes, just like Mark Meadows says, how tone deaf these people are. So, dear Governor Healy, I am writing to express my concerns regarding the ongoing internal investigation within the Massachusetts State Police, with specific reference to the Karen Reed trial and the suspension of Trooper Michael Proctor following the revelation of his derogatory text messages concerning Miss Reed. And what's even funnier too is she starts dropping in stuff about free speech, and I'm like, do you even like what? What planet are you on, woman? A significant portion of the public has labeled Trooper Proctor as corrupt and biased. Well, we didn't do that. He did that. So, no. However, it is essential to recognize that, like every US citizen, he is entitled to freedom of speech under the First Amendment. Yeah. And you know who else is? Turtle Boy. Turtle Boy, who was arrested for witness intimidation for the same thing. So it's like I love these people because they want to argue both sides, but then they don't understand that what they're actually arguing makes zero sense. The fundamental right, which is equally exercised by protesters outside the courthouse, should not be grounds for vague and unreasonable suspension. It wasn't vague. It wasn't vague at all. It wasn't vague because he didn't do his job. He's not a good cop. He doesn't know how to properly investigate a crime scene. This case just cracked that open and just enlightened it to the rest of the world. And he didn't have to say a dang thing on that stand. He brought that on himself. So what the heck are you talking about? Every citizen has the right to be critical and to express their opinions. Yeah, but most police officers don't do it over text to their buddies and then uh, literally text you, the sister, that, hey, it'd be so much easier if this woman just unalived herself. And you agreeing to that. Like by you doing this, I don't know what you're trying to get out of it, but I can guarantee too, just being in email marketing, Healy probably has spam filters, and this probably went right to the spam folder. So she's probably never going to see this. But I think it's funny that we're all able to read this now. There's no concrete evidence to suggest that Trooper Proctor maliciously planted evidence. The whole case is your evidence. Nevertheless, while his text messages are contrary to the ethical standards expected of law enforcement officers, so you admit it, okay, they remain protected under the First Amendment. These communications, although unprofessional, do not constitute a valid reason for his suspension. Well, how about the fact that he literally contaminated evidence and then laid out unsupervised John O'Keefe's clothing on butcher paper? What about the fact that he waited for days to go back to 34 Fairview to see if taillight pieces would just reveal themselves? What about all of that? What about the fact that he seized Karen Reed's car and called a tow truck company without having a warrant and took her phone? Oh, and then what about the part where he was looking for naked photos of her? And actually going through her cell phone itself like you're some creepy pervert locked in your mom's basement. Like, no. No. Nobody cares, Courtney. Nobody cares about your brother. I'm sorry. He did it to himself. He did. The manner in which these messages were introduced into the trial raises questions about the integrity of the judicial process. I can't believe that. Wow. It appears that the introduction of these texts may have been politically motivated. Are you serious? What the heck does that even mean? By who? The DA's office? Especially in an election year. The case has caused considerable public uproar with allegations of corruption that merit through investigation. It is crucial to examine not only Trooper Proctor's actions, but also the broader context in which these communications were utilized against him. Advocates for freedom of speech, such as bloggers like Aiden Carney, this is the best part, should recognize that this right also protects Trooper Proctor's communications, irrespective of their content. Like, are you really trying to defend him making fun of Karen Reed's medical condition because of freedom of speech? Like, and I think this is where people on both sides of the fence can kind of come together, and we can all collectively, whether you think Karen Reed is guilty or innocent or not guilty, whatever you believe, I think we can all collectively agree that Michael Proctor is a scumbag. And he deserves everything he's getting right now because he put himself in this position. It's not people like Karen Reed. It's not the court. It's like you want to blame everybody, but why not look at the man himself and say, "Hey, what? Hey, brother, why did you say all those things? You know that probably wasn't a good idea. Why? Because you were participating in the conversation too." I think it's only a matter of time before people are going to start looking more and more at you, Courtney. And if you want to end up like your brother, then hey, that's fine. But I'd be careful. I'd be careful with what you say and what you do. And I would actually take a play out of your brother's book and maybe just not say anything. Unless he's the one who's conducting and orchestrating all this and you're just being his mouthpiece. But why is the governor going to stop what she's doing to give a shred of a crap about your brother? Because nobody does. Because he spat on the badge that he wore and he disrespected not just John O'Keefe, not just his family, not Karen Reed, but every other brother in blue. Every other good cop out there, he just ruined it for all of that. We want to believe in our system. We want to believe there are good people. We want to believe that there are good police officers we can trust that are going to take investigations seriously like this. Despite what you believe, it doesn't matter. Keep those biases to yourself. This is what you signed up for, brother. And now that you got caught, it's not fun and games anymore. And if you're having your sister be your mouthpiece, then that's just a sad move. But I would do what he's doing and just shut the heck up because nobody cares. This is the last thing on anybody's mind right now is what's going on with your brother. I urge you to investigate the underlying issues of corruption and ensure that justice is administered fairly. It was when he was relieved of his duties and suspended without pay. That's called justice because he's somebody who doesn't respect the badge. He doesn't respect his brotherhood. He doesn't respect it because if he did, he would have conducted a fair investigation. And a lot of us can get over. I mean, the text messages were grotesque. They were a grotesque characterization of who he is as a person. But if he conducted a fair investigation, I think a lot of us would be like, all right, he's a scumbag as a person, but at least he did his job right. At least he did his best as an investigator. It's not just about the text message, Courtney. It's not just about that. It's about everything of what he didn't do. It's not even what he did do, it's what he didn't do, what he failed to do. And that's why you people are just so get your heads out of your freaking siblings' butts and just look, pay attention. Both law enforcement officials and their critics should be held to the same standards of fairness and freedom of speech. Thank you for your attention to this important matter. I mean, it's just it's so laughable. And then she posted, I guess, like this, like, "Help me and my family" post. uh, asked for help. "Hi, everyone. As you know or have heard in the news, my brother is under an internal affairs investigation." Not a great way to start a sentence out, by the way, Courtney. "With the Massachusetts State Police over the misuse of his personal text messages." It's not just that, Courtney, but okay. "We have learned that the state police is potentially going to impose the most severe type of punishment, which is termination. Michael has had a 10 plus career, I guess she meant tenure, a 10 plus year career with the state police that is consisted of promotions, accolades, and not one violation." Well, I mean, when you look at the department around him, the standards are pretty low. So, I mean, I can buy that. He probably was promoted a lot. He probably was given a pat on the back a number of times because they're all a-holes. Not all of them, but most of the ones dealing in this case. So yeah, it's not surprising that he would have had a 10 plus year career that's consisted of all these wonderful things when they're all scumbags doing the same crap job that he was doing. That's why he thinks it's okay. He has been used in a political chess game that has nothing to do with the Karen Reed investigation he and his office led with fidelity. "I am trying to help push an email campaign to the governor and the colonel of the state police ahead of Michael's IA interview next week, where we learn of his final punishment. Please help me by mailing Governor Haley and Colonel Mo." Like, again, like, what do you think Healy's gonna do? What do you think, honestly, Courtney? Do you think she's going to, with everything going on, like I said, and this was before, to be fair, this was before the attempted assassination on Trump. But still, I mean, even now, do you really think she's gonna be like, "Oh yeah, let me help save, let me make myself look even better in the eye of the public by reinstating your brother because you sent me an email about free speech"? No. Do you not know? Did you not see the statements that she put out about Proctor? And whether it was BS or not, she's already made a stance. And if she goes back now, I mean, that's career ending. So no. I don't know. I don't know what goes on in these people's minds. With that being said, what do you guys think? I'm losing my voice. I'm so exhausted. What do you guys think of Courtney Proctor's ridiculous plea to Governor Healy to see if she can help her brother out? I mean, the stuff only gets crazier and crazier by the day. And what do you think about Bev not being on the bench at Monday's hearing? What do you think about the defense's response to the Commonwealth's opposition? I want to know in the comments section below. And if you enjoyed today's video, make sure you hit that subscribe button. Make sure you hit the notification bell so you never miss another video from me. Make sure you hit that like button too, because that shows the YouTube algorithm that this is newsworthy news and that it is important, and it helps reach this story out to so many more people. And I know that things for post trial, there's more news going out every day. There's other cases that we're going to be covering here on this channel, but that doesn't mean that we stop talking about this one, because at the end of the day, there is an innocent woman whose life is quite plainly on the line, and she has to go through just all of this BS again. So we need to put even more pressure now more than ever on these agencies, on the Massachusetts State Police, in conjecture with the governor's office, on the DA's office. And if you want to make a donation to support this channel, you can scan the QR code at the very top of your screen. That'll take you to my Cash App. Any contribution is incredibly generous, and if you leave me a note, I will read that note at the very end of every video, as well as give you a shout out on the end screen. And at the end of the day, I will take 20% of all proceeds that are donated to this channel and make a direct donation to the Karen Reed Defense Fund. Or if you feel more comfortable just donating straight to Karen Reed's Defense Fund, I have the link for that as well in the description below. Next, we're going to be covering the Ashley Benefield case. She is the Florida ballerina who was accused of murdering her late husband, Douglas Benefield, in cold blood, where she claims it was an act of self defense. So we will be getting into that case as well. That's ironically, they're starting jury selection, I believe, the same day that this hearing is going to go on. So we're going to do our best to split our time there. But I'm going to have a update on they had a pre-trial motions hearing today. So there was some new updates, some quick updates in regards to like certain evidence that's going to be allowed in as well too. So that case will be kicking off next week. We'll be following it very closely. So if you want to stay updated on all things in regards to that, make sure you hit that notification bell. All right. Thanks so much for watching, and I'll see you in the next one.